Hello, good afternoon. I'm Maggie Stewart. I'm the co-chair of the immigration section at the BHBA, and I'm here on behalf of the immigration section and also the family law section for a really exciting CLE today on the intersection of immigration and family law. We're glad that you're here. You're going to be getting a CLE certificate, and that will be provided to you by BHBA after we're finished. Welcome you to use the Q&A box to ask your questions as we go along, and I hope that we have a great time. I'll turn it over to my co-chair Joanne Litt to introduce our panelists today.
Thank you. Hi everyone, welcome. So our two panelists that we are so lucky to have today, our first is Jinna Kang, who a lot of you probably should know from BHBA. She is currently on the board of governors and was formerly the co-chair of the family section. She's a partner at Enenstein, Pham and Glass in Los Angeles, and she has spent the last 11 years of her practice devoted solely to family law matters. She is also one of the only two board certified family law specialists in California with Korean language fluency, and is the first and only Korean speaking fellow of the International Academy of Family Lawyers. And our other attorney speaker is Mr. David Raft. He is the senior supervising attorney at Global Immigration Partners. Mr. Raft has been practicing law since 1989 with a focus on immigration and nationality law since 1991. He is certified by the California State Bar as a specialist in immigration and nationality law since 2000. And he has worked with many businesses and families and bringing both immigrant, non-immigrant visas, doing all sorts of immigration matters, including investor visas, specialty occupation workers, multinational transferees. He is also the former chair of the Orange County Bar Association's immigration section, and he has also written numerous articles for industry publications and has spoken regularly at various bar association meetings. So welcome, David and Jinna. And would you guys like to introduce yourselves and talk about how you came into your practices?
Sure. David, go ahead.
Okay, so thank you for inviting me to speak to the Beverly Hills Bar Association. I first somewhat fell into immigration law. I was a relatively young attorney back in February 1991, and I had an interview with a law firm. I've been practicing mostly business transactional law prior to that, and that law firm had an immediate need for somebody in their immigration section, and they invited me to go with the managing partner of the immigration section to immigration the following week for interview for a client. And then I was very interested, having been an immigrant myself. I'm originally from Montreal, Canada, so I fell into immigration law in one respect, and then I also fell in love with it and have been dedicated. I've dedicated my practice solely to immigration law matters since then, primarily business immigration, but I also manage our family law practice at our Global Immigration Partners firm. So thank you.
Very cool. So I, as many immigration attorneys may be, am an immigrant. I came to the US when I was 15 from Korea. So immigration law was the only law I had direct contact with until later in life. So when I was going through college, I had then boyfriend who then became my first husband, who was undocumented. So I went to a consultation with him to get him a green card. And the attorney we met with was an attorney who got our family green card. And she asked me, so what are you doing these days? So I said, well, I'm graduating from UCLA. And she said, do you want a job? So I took that job as a legal assistant. I was doing immigration for 3 years. And when I gave birth and I, with my 1-year-old, started law school, I went through my own divorce. So it was time for me to get inside of family law. You know, it was very timely. So I started clerking for a family law specialist in Pasadena. And that's how I fell in love with, first I was in love with immigration law, and then I cheated on immigration law to fall in love with family law next. And it was so fascinating. Everything was very personal. It was more than just the money. So I loved both immigration and family, but I stayed with family as I'm staying with my second husband second time is always a charm. So that's how I got into doing family law with a hint of immigration law. And I love both areas of law. Okay, so David, you can start.
Okay, so I'd like to start with some basics. And I think that most of this presentation will cover basics, I think primarily for family law attorneys. So in the context of immigration law, you have to understand that there's two primary ways for people to get a green card. One is through family sponsorship, the other is through business. So obviously this is going to be focused on family sponsorship. There's certain categories of relationships that could result in sponsorship. So that you understand a chain migration or immigration like President Trump had commented about and was trying to get rid of is very limited in scope. US citizen or permanent resident can sponsor only immediate family members. So that's very limited, so that only, as an example, a US citizen can sponsor their parent, spouse, or child, or children. A permanent resident can sponsor, and a US citizen can also sponsor their siblings, so brothers or sisters. A permanent resident, on the other hand, is very limited in who they can sponsor. They're limited to only being able to sponsor their spouses and their children. So a green card holder, permanent resident, is not eligible to sponsor their parents, nor are they eligible to sponsor their siblings. In order to be able to sponsor either of those relationships, they'd have to first become a US citizen. There's also certain restrictions on who can act as a sponsor. So generally speaking, if there's a legal natural relationship between the US citizen and the parent, child, or sibling, that's okay to be the sponsor for that individual. But when sponsoring a spouse, if the US citizen or permanent resident has a felony record for domestic abuse, that could preclude them from being a sponsor of their spouse. When sponsoring somebody, also, there is a requirement that the person that's acting as the sponsor has to be able to file what's known as an affidavit of support that will be submitted to either the Immigration Service at the time of the filing of the person's green card interview application, or if the person's having their interview overseas at the US Embassy, it would be submitted to the Department of State for processing. And
so David, if both the lawful permanent resident and a US citizen, both of them can sponsor their spouses for green card, is there any difference between the two? Like timeline?
That's a great question. The short answer is right now there's no difference in terms of timeline, but there has historically been a pretty significant backlog because for US citizens sponsoring their spouses, their parents, or their underage children, there's no quota system in place. And just for the record, underage children are also, they're under the age of 21, and the child needs to be unmarried. If a child marries before they turn 21, or they turn 21 through the process, that could end up making the case subject to a quota system. Now, a permanent resident sponsoring their spouse or their children, those cases are subject to quota systems, and there's limitations on the total number of green cards available per year. But for the present moment, and for probably the past 5 or 6 years, or roughly 5 or 6 years, there hasn't been a quota backlog for the category in which a permanent resident would sponsor their spouse. And that's known as the family second preference category.
Awesome.
So speaking about the affidavit of support, as I mentioned, when a US citizen or permanent resident is sponsoring their family member, they are required to submit this affidavit of support, which creates a binding contract that requires the person that's the sponsor to be responsible to ensure that the individual is not going to
receive certain benefits that could result in the person being deemed a public charge. So included in that affidavit of support would be a requirement that the person has to submit evidence of their income. And then the government also will want to see copies of their tax returns, typically for the past 3 years, copies of W-2s and 1099s. And we usually also submit evidence of their most recent bank statements and payroll records, or if they're a 1099 worker, then we'll submit copies of bank statements just to show deposits that have been made into their bank account. And there is a certain threshold requirement that an individual needs to be able to demonstrate as far as their income. So if a person's income is below the US poverty guidelines, and we've shared the link for the most current poverty guidelines on this slide, the person will potentially need to, well, let me back up and say the person could overcome a concern that the government would have by presenting evidence that they have assets that equal or exceed 5 times the difference between their current income and whatever the poverty guideline may be. And with the evidence of those assets, they should be able to overcome the government's concern about their qualifying to submit the affidavit of support. If they're not able to provide any such evidence, so for example, if the sponsor might be in college, then they don't have any income whatsoever, they may need to get somebody to act as a co-sponsor or a joint sponsor. And then that person would be completing their own affidavit of support and would equally be as liable to ensure, I should say, that the foreign national does not end up getting public charge benefits that they may not be entitled to. So,
After military.
Oh, yeah. So people that are in the active military, just so that you're aware of it, they're, to kind of back up with the federal poverty guideline report, for people that are in active military, they need to be able to demonstrate that they meet the poverty guidelines and or exceed it at the exact rate that it's set up. So for example, for a family household size of 2, the rate is, I can't remember the exact number, and I don't have like access to the internet right now, unfortunately, but the rate would be likely to be about 21,000, maybe 22,000 for a family household size of 2. If a person, however, is not in active military, then they're responsible to demonstrate that they have income that is at 125% of the federal poverty guideline for their household size. When calculating household sizes, the Immigration Service and the Department of State looks at the individual that's the sponsor, the US citizen or green card holder. They also look at who is being sponsored, and if there's any other individuals that are being sponsored besides the main beneficiary of the case. And if the US citizen or permanent resident has acted as a sponsor for any other affidavits of support. And then finally, if the US citizen or permanent resident has anybody else that lives with them and is dependent on them. And so oftentimes you might have a person that's a sponsor where, although they might be just sponsoring one person, their household size could end up being 4 or 5 people because of their commitments and who they list maybe as their dependents and who lives with them.
So when the sponsoring spouse does not qualify as having enough income or even access to these assets, then what type of people have you seen co-sponsoring or signing the I-864A?
Most often it's going to be the sponsor's parents. It's typically the case that we see. There are certain circumstances where if the foreign national that's actually being sponsored is employed, that individual could actually help their spouse to demonstrate their income and overcome the need for a co-sponsor.
So would it work like a combine the income household income total meeting the guideline?
Yes, it would. And
Uh,
so it just,
Oh, sorry. We have a couple of
It-
questions
Oh,
about
sorry.
the sponsor petition, affidavit of support. First question, have you had cases where the sponsor is just over the minimum, like a few $100s? How has that turned out?
I haven't had it like meeting that threshold, but definitely close to it, like within $1,000 or so, and it hasn't been an issue when we have the evidence. So we also usually ask for a letter from the person's employer, or if they're independent, like if they're a consultant, get letters from their clients and documentation as to the income that they're receiving, you know, like I mentioned, copies of earning statements, bank statements, anything else that they can provide. And then I haven't had an issue with getting that case approved.
I think generally,
I-
right, the closer you are to that, the closer you get to that threshold, that you should include more documentation of other income or really solidify that income or include assets.
Yes. Yes. One of the things that people should also understand is that when the government looks at the affidavit of support, they're analyzing a person's tax return and they go by the adjusted gross income that's listed on the tax return. So the person might be earning well above the federal poverty guidelines, but if their adjusted gross income is below that number due to any type of offsets that they have on their tax return, the federal government will ask for additional evidence to show that they could act as a sponsor without getting somebody to come into the picture as a co-sponsor or joint sponsor.
Okay. And then we have another question. It says page 6 of the I-864 provides that, quote, if an intending immigrant becomes a lawful permanent resident in the United States based on the form I-864 that you have signed. The question is, what does it mean to be considered a lawful permanent resident in the United States based on a form I-864? I think that may be a misreading of the sentence, right? What loss of proposition? What does it take to be considered a lawful? Okay, that's the same question. I don't think it's saying that you become a lawful permanent resident based on the form I-864.
No, I mean, the IA-64 is a form that's required in order to be considered for approval of a person's green card case. And just so people understand, the term green card is a singular term for a permanent resident card. So when we're talking about process, when a person's applying for permanent residence or they're applying for a green card, it's pretty much one and the same. It's just everybody refers to the permanent resident card as a green card because the original card itself had these green squiggly lines running across the face of the card, and that's what it became known as. Like when I had my permanent resident status, my card had a blue border around it. Then later on, it had a pink border. And then now it's going back to where it has like a green border around a certain element of the card, but it's all interchangeable.
Based on conditional or not, or non-conditional, is that right?
Well, it doesn't matter. I mean, if a person gets their conditional resident status, the person that's the sponsor still is required to comply.
Oh, you're saying they just changed the card. I thought they changed the card based on like something in your status changing it.
No. They do physically send a person a new card, and that card would be good for 10 years. But the requirement that is imposed on the sponsor that has filed the underlying petition and filed the affidavit of support doesn't fall away or disappear until the green card holder has either become a US citizen or we can show that that person's worked for 10 years. Technically, it's 40 fiscal quarters.
Okay. Another question says, what happens if the intending immigrant and sponsor submit the appropriate paperwork to US immigration, including the affidavit of support, and the intending immigrant moves to the US, marries a sponsor, and within a few months of marriage, the sponsor files for divorce and subsequently withdraws sponsorship? I think, I mean, you can answer that now, or we can just get to it with. right? I think
Yeah,
later.
I'd say why don't we wait until the end so we can make sure we cover all
Yeah.
the entire presentation.
Right, okay, and then there's another question. Recently, a court ruled that the I-64 did not apply because Enenstein did not become a lawful permanent resident. I think we'll touch on that later also as to
Yeah.
when I-64 comes into, like, when it, I guess, launches. Okay,
Yeah.
Okay, so my next slide has just that, premarital agreement versus affidavit of support. When there's a conflict, what do you do? But I can't figure out how to go back a slide, so the link to your written materials, if you can click on it now and follow along, I would appreciate it. Otherwise, I would have to like restart the slide, so I really am sorry. I am very technologically challenged this morning, and it's afternoon already, so I am challenged all over. So premarital agreement. So when you have an affidavit of support signed by the petitioning spouse, US citizen or lawful permanent resident, signed the affidavit of support and filed it with USCIS, that's a contract, binding contract between the federal government and the petitioning spouse. Then there's another contract between the petition spouse and the petitioning spouse. Often this contract would be the premarital agreement, and the petitioned spouse would be waiving spousal support. These are two very valid contracts, but when there is a conflict, which one controls? So in the case of first impression in California in 2017, we have the marriage of Kumar case, 13 Calap 5th, 1072. And this case says the immigrant spouse has standing to enforce the support obligation created by an I-864 affidavit in state court. So although this is a federal contract, California will honor that contract, and it will allow the petition spouse to enforce that contract in her or his divorce case in state court. And it also says immigrant spouse has no duty to mitigate damages. So that's like Gavin warning. In Kumar, the petitioning spouse was saying, well, she had duty to mitigate by looking for a job, and she didn't, so she's at fault somehow. But marriage of Kumar says, when we're talking about the affidavit of support and the spouse, the obligation to make sure that the petition spouse is financially sort of supported, so it never becomes, she or he does not become public charge. The petition spouse has no duty to try to not become public charge. Then the question becomes, then how much spousal support is this petition spouse entitled to? We don't know, because we don't have a case that actually says how much, but all we know is that it has to be at an income of at least 125% of the federal poverty line, and that's for 10 years. So even if the petitioning spouse thought, well, I had the petition spouse sign prenup and we've been married for only a couple of years, per California spousal support statute, maybe half the length of marriage and I'm off the hook, even if the PMA is set aside. Not so according to Kumar. So you are on the hook for 10 years. So before you fall in love with a foreign national, you should be thinking twice about signing affidavit of support. And David briefly touched that most US citizens or lawful permanent residents can petition their spouses for a green card or permanent residency. But there is an exception if the USC spouse has a felony conviction for a crime against a minor, then that person cannot sponsor the foreign national unless he or she can demonstrate that he or she will not be a threat to the foreign national family. So David was saying, if you have a domestic violence perpetrator who perpetrated this abuse on a minor, then that person cannot sponsor for a permanent residency of a foreign national. But I had a case where it was the US citizen who had a conviction of, what is it? Child endangerment and sexual harassment against the minor. He was like 20 and the victim was about 14. So he had that conviction, and that minor had nothing to do with green card petition or anything. But later in life, when he found his bride, she needed green card petition, and he said, well, I'm a US citizen. Even if you are out of status, US citizens can petition, so don't worry about it. So although she had status, she came on a student visa, and then she had a change of status to H-1B, which is a work visa. She had valid status, but because he misrepresented to her, you know, I can get you a green card easy, you have no reason to maintain your H-1B status. She, believing his statement, she didn't renew her H-1B and fell out of status. But for 10 years, USCIS kept saying, well, you are a threat to this foreign national because you have a conviction of a crime against the minor. So David, in a case like this, how do you deal with these people?
Well, it's a tough one. I would really have to look at what other options are available to the individual, and if there is an exemption to that could be submitted to immigration to demonstrate that the person should be entitled to act as a sponsor. I would also look to see whether or not there's any basis to qualify the person to reinstate their non-immigrant status, and then possibly see if their employer would be willing to sponsor them for a green card.
So in my case, the non-immigrant spouse was a victim of domestic violence. So after having 2 kids, almost 10 years of marriage, she was constantly under the threat of physical harm and verbal and financial and emotional, everything, the whole enchilada. So in that case, she did have a way out to petition herself under VAWA. And I think we're going to cover that a few slides now. So I will move on to the next slide. It's you, David.
Okay, apologies on that. The next slide is actually a reiteration of what I had mentioned earlier in the presentation about the classification of relationships that are eligible to be sponsored under the family categories. And then in terms of the filing, there's certain documentation that the government requires to be submitted in support of the sponsorship. So for example, if a person's sponsoring their spouse for a green card, immigration is going to want to see a copy of the marriage certificate. And then also if either one of the spouses have been previously married, then they would want to see a copy of the divorce or annulment, not only for the most recent marriage, but if a person's been married 4 or 5 times, we have to document that each and every one of those prior marriages had been ended by divorce, annulment, or the death of the past, spouse. So, I could tell you that that documentation could take a long time to obtain, particularly if a person had been married in another country and documentation is not readily available. I had a case recently that was just approved by immigration where a US citizen sponsored her mother, and it took the mother over a year to be able to get a copy of her birth certificate from the South African government. So there's a varied amount of documentation that's required for the filing, and it really is dependent upon the nature of the case as to what evidence is required. So to give you an idea as well, like the family fourth preference case, the law requires that the US citizen sponsor needs to present their birth certificate, their brother or sisters or brothers and sisters' birth certificates, as well as the marriage certificate of the parents to show the familial relationship. Then just normally when we're filing one of these cases, we'll typically include evidence of, especially with a marital case, a marriage case, we'll like to include evidence that the spouses have a bona fide marital relationship. So besides the marriage certificate, we'll ask if they have bank accounts together, if they've got a lease agreement or they have a grant deed to a property together, if they have a premarital agreement in place. That's good evidence that there was thought put into the marriage, and any other evidence that they may have to present. And then what I would normally advise them is to continue to compile this type of evidence so that when they ultimately have their interview, they'll have a solid presentation of, you know, this evidence to submit to the officer that's going to interview the couple. And just wanted to let everybody know that the Defense Against Marriage Act does allow same-sex spouses to act as well, the U.S. citizen could act as a sponsor for the person that is a foreign national. Up until DOMA was enacted into law, even if a person married in a jurisdiction that allowed for same-sex marriages, because it wasn't recognized by federal law, it wasn't possible for a person to qualify for an immigration benefit.
So I do want to go back to answer the question regarding the I-864 providing that the contract between the federal government and the petitioning spouse kicks in when the petition spouse becomes a lawful permanent resident. So I did have a case recently where it was just that the felon spouse was the petitioning spouse, and the petition spouse had done nothing wrong, just had 2 kids and was working really hard, and her green card or permanent residency kept getting denied, and repeatedly asked for more documents, RFEs, but and she had a PMA signed. When we had DV case, we were asking for temporary support. The opposing counsel was arguing, but under I-864, it says when the petition spouse becomes a green card holder, that's when the contract kicks in. So since her green card never got approved, he doesn't have any obligation to support her financially. So in that case, the workaround for me was to go for the domestic violence restraining order and ask for spousal support, because you have many cases that support temporary spousal support, even when there's a dispute about the validity of PMA, or when things are not like set in stone, you can still get temporary spousal support, especially for victims of domestic violence. Even in regular home court, you can do that, but I think you have a stronger argument for it in domestic violence restraining order case. So we used that argument, and I successfully got the other spouse to agree to a voluntary support before we had to spend a lot of money and time in going over whether this is kosher. Can we set this aside or not? Because for relatively short marriages, it's better to negotiate better than actually try the case to decide whether the PMA is valid or not. So for immigrant spouses who need support, yes, it is true that if the status never changed from a non-immigrant to an immigrant legal permanent resident, you can still make other arguments to get the other spouse to come to the negotiation table to get some support. Next is David again.
Yeah, so there are circumstances where an individual that is applying for a green card may have a issue in their background that would make them ineligible for permanent residence. Most commonly, that would be a situation where a person may have overstayed their visa status, or potentially individuals that had come to the United States without inspection, and then they're entitled to a green card through their marriage to a US citizen, or maybe their parents have gotten green card and has sponsored them, and the person may be entitled to move forward with a green card interview process, but for whatever reason, they could be refused the green card because of their past being subject to, or they're currently being subject to what's known as a inadmissibility issue that under federal immigration law would prevent them from either getting a visa or getting a green card. So in a situation where a person may be subject to one of these grounds of inadmissibility, they may be eligible to apply to the Immigration Service for a waiver of that inadmissibility ground. And it's important to understand that these waivers are not automatically granted. They're at the discretion of the Immigration Service. And they do require, generally speaking, that the individual be able to demonstrate that their US citizen or permanent resident spouse or parents would suffer extreme hardship if they're not allowed to be granted permanent residence, basically having that waiver be approved. Now, if somebody's here in the United States, but they're not eligible to have the green card interview be processed here in the United States, they would have to go back to their home country to go for the green card interview. If they had been in the US illegally or unlawfully present in the United States for more than 6 months or more than 1 year, if they leave the country to attend that green card interview, they would trigger what's known as an unlawful presence bar, wherein they would either be subject to a 3-year bar if their unlawful presence had been for more than 6 months but less than 1 year. That bar escalates to being a 10-year bar if their unlawful presence had been for more than 1 year. So to give you an example, I have a client that I'm working on to qualify for a green card through employment sponsorship. His mother, father, and all of his siblings have either green card status or US citizenship now. He was the only one that didn't get the opportunity to qualify for the green card with the rest of the family because he had aged out. He had turned 21 before the green card case qualified him. He does qualify for a waiver because of the fact that his parents are US citizens. And because he's here in the United States, we could file this waiver application and get a predetermination by the Immigration Service. So that way, before he goes for his ultimate green card interview in his home country, he'll know for sure whether or not that waiver has been approved. If the immigration denies the waiver, he could remain in the United States based upon his currently having legal right to be here pursuant to what's known as DACA, which is deferred action for children that came here with their parents. It's technically known as deferred action for childhood arrivals. That's the DACA acronym, or that's the wording of the law that's created the acronym for DACA. So getting that waiver approved by showing that his parents would suffer extreme hardship would be of tremendous benefit, because it allowed him to then go to his home country. And when he goes for the interview, as long as there's no issues that arise at that time, he should be approved for his green card, or what's known as an immigrant visa, and then be allowed to travel to return back to the US. Now, in some situations, people that might be here in the US and they are eligible to have the green card interviews, but for some ground of inadmissibility, they could apply for the waiver to the Immigration Service as part of their green card application. They still need to demonstrate that their family members would suffer extreme hardship. And typically the process would be relatively involved and hopefully ultimately approved by immigration. But again, it's important to understand that those waiver applications are at the discretion of the Immigration Service. The final one that you need to be aware of is that if a person is not in the United States, they actually would have to go for their green card interview at the US Embassy, have the embassy staff make the determination that they're not admissible because of whatever action created that ground of inadmissibility. And then at that point, they could submit their waiver application, with the waiver application processing probably delaying the case by another 6 months to a year.
So there's a question if there is a state statutory law or case law that supports the proposition that the support obligation becomes effective when sponsor signs the affidavit, or is it only effective upon intended immigrant receiving a green card? I think I covered that already. The permanent residency needs to be established first for that contract to kick in. So what if the sponsor withdraws sponsorship which arguably interferes with ability to obtain green card? So in that scenario, it would really depend on how the sponsorship was withdrawn. If it was a bona fide marriage and the spouse just withdraws the petition for a green card and you haven't even started getting him on the hook or her on the hook for financial obligation, obviously it hasn't been that long for vast majority of cases. It would have been very short amount of time. And if there's no PMA signed, then you can go for short financial support based on the regular spousal support statute, or you can ask for, if there is a PMA signed and there's a dispute as to whether that is valid or not, as I said, this can be domestic grounds for domestic violence restraining order. You can ask for he unreasonably or maliciously interfered with my immigration status. Now he's doing that as part of his coercive control. Then you can file her or his request for a restraining order and get financial support that way. Okay, visas, David.
Right, thank you. So the K visa, I'd like to probably canvass the room if we were live, but if people have heard of 90 Day Fiance, that TV show, this K visa is what they're talking about. So if a US citizen falls in love with a foreign national, that foreign national typically would be outside of the United States. They have plans to get married. They would like to get married in the United States. There's only a limited number of visas that are available to allow for a person to be in the United States, get married, and then remain in the United States and complete the green card process in the US. I'll cover those on a slide in one of the future slides, but the K visa is actually the appropriate visa for the US citizen to initiate, to qualify their spouse for that visa and get them in the US, after which they could get married. They do have to get married within 90 days of their entry. And then after that, the foreign national could apply for his or her green card with the Immigration Service. Now, realistically, processing of this K visa does take a long time. Prior to the pandemic, I would guesstimate with clients that they would be looking at anywhere from 8 months to a year and a half. That's how long they're looking at. Now, with the delays that have resulted due to the pandemic, both stateside with the Immigration Service, as well as overseas with the State Department and their embassy staff, it could take 2 years or longer for a person to be entitled to get the K visa and to actually get the interview, I should say, because it doesn't necessarily mean that they would be issued the K visa when they go for their interview. There may be further delays if the State Department officer had some sort of concerns about the marital relationship. The K2 visa is also available for the dependent children of the foreign national. And then there's another visa category that was created into law approximately in 2000 that is known as a K3 visa, and then dependent children can also get a K4 visa. It was meant to be made available so that if US citizens married people overseas, they could sponsor them for a green card. Then they can turn around and file the K3 visa case for them. And that would allow the individual and their minor children to be able to join them in the United States while they wait on the green card process. It seemed great, but in reality, immigration processing of the K3 and K4 cases, it take well more than a year. And then what we've seen is that when a person sponsors their spouse for a green card, the likelihood is that they'll get their green card faster than they'll get scheduled for a K3 visa. So I don't even recommend going forward with the K3 anymore. Congress meant well when they passed the law, but immigration just has not implemented it in accordance with Congress's direction and intent.
So if it worked as they intended it to work, it would be that you would go to a foreign country, meet somebody, fall in love, promise to marry, and then you come back home, but you would have your fiance get the K1 visa, fly her over, and within 90 days of entry, you would marry that person. But in reality, that's not the timeline you're looking at.
Right, it's not that quick. It's really going to be probably a year and a half minimum, if not longer, until they'll be able to come to the United States. So there may be other options. And I mentioned at the last bullet point of the slide that there's this H-1B and L-1 sponsorship. Those are work visas where the law specifically allows a person to come here pursuant to the intention of working under those work visas. And then if they do get married to a US citizen or permanent resident, the law allows them to file for their green card interview, and there's not going to be any concerns with what their intentions were in coming to the US, because those work visas are known as dual intent visas, where it's okay to be here on a temporary work visa and then also want to get a green card down the road in the future. We'll talk about other non-immigrant visas in another slide up ahead.
Okay. So I have VAWA and immigration. Oh, it's actually your thing.
Yeah, I mean, I think that you could probably speak more to it as far as the family law aspects of it. But a person who's a victim of domestic violence could file a case to the Immigration Service to qualify for a green card. When they file that case, they're also going to be entitled to apply for their green card interview. They do not need to wait for immigration to approve that VAWA case. When they file it, they'll also be able to potentially qualify for certain state or federally funded benefits, as long as the immigration issues a prima facie notice that they appear to qualify for VAWA.
So does it have to be physical violence? What form of abuse do you have to be subjected to?
No, it could be also emotional abuse as well. So either one.
How do you qualify a case for VAWA case? Like what requirements do you have?
If a person has temporary restraining order or injunction in place against their spouse or their parent, if they have evidence of their having called the police, like 911 calls, if they have evidence of their being admitted to a shelter, if they sought counseling, if they've been hospitalized, if they have evidence of actual physical battery, all of those types of evidence could be presented to demonstrate a very strong VAWA case.
So
Again,
go ahead.
I was just going to say that when we're looking at somebody who doesn't have a lot of evidence of their being abused and they're relying upon their word, that makes it much more challenging to get the immigration service to accept the case and find that the individual is a credible applicant.
So in 2000, I think it was 2000, when I was working at an immigration law firm, we had a client who was pursuing a VAWA case, and there was no physical or per se emotional abuse. What the problem was she got married, she moved, and he later finds out he's gay. So he just abandons her, finds a lover, and they are not living together. So she is doing her own thing, working and having a fruitful life. Then they go to the green card interview, and the husband, they were in good terms. So the husband came, but he couldn't even remember the home phone number. Back in the day, we had home phones. So the green card was denied. The interviewer thought that this was a fake marriage. And she really had come to this country on a bona fide marriage, but now he was gay. So there was, not by her choice, but she sort of was not married bona fide anymore. So based on that, that abandonment and emotional abuse back 2 decades ago, she did get a green card. So the VAWA case did work. So it's not just physical abuse or battery, or when you're saying extreme cruelty, we're thinking, oh my God, bloody face. But emotional abuse, coercive control, all of that really works.
One of the things that's also important to know is that there is an exemption where people that are VAWA applicants do not have to rely upon their U.S. citizen or green card sponsor, so to speak, to submit an affidavit of support. They'll still be eligible to get a green card without that affidavit of support.
Awesome. So Domestic Violence Prevention Act, since we have majority of you doing family law, you know what this is, abuse. It doesn't have to be physical. And we have 6320 amended to include coercive control, and right down here, I was really happy to see that it actually added specifically immigration status. So any threats of deportation, intimidation, or threat of force, and it's something to do with immigration, that's part of abuse that can fall under Domestic Violence Prevention Act, and also engaging in reproductive coercion. So unreasonably pressuring somebody to get pregnant, or pressuring somebody to have abortion. So anything to control pregnancy outcomes, those do qualify as coercive control under DVPA now. Maggie?
Hi, I'm just going to jump in. There's a question. I'm not sure that it's been touched on. It's if a client has a restraining order against him or her, does that visa restriction to sponsor their foreign spouse stay with them forever? Or when would it fall away if they, in that case?
So it's a conviction, felony conviction. And if we're talking about domestic violence restraining order in family court, that's a civil restraining order. So that you wouldn't have to worry about that. So if we have a criminal conviction for battery or something of a crime of moral turpitude, then you have something to worry about. And it will, like in my case, it will stay on forever. You can't, yeah.
So the distinction is that if there's a criminal conviction for battery or then it will stay forever.
Forever.
If there is a civil restraining order, such as in family court or another civil court, then that won't affect their ability to sponsor a person for immigration.
Yep.
Thank you.
U visa.
Yeah, I'm just going to try to be quick because I realize that we're running out of time quickly. U visa is available for individuals that will cooperate with the police and prosecution related to a domestic violence matter. And I just think that unless Jinna has something else to add to it, we'll continue on.
Right. So even if you're not married to a US citizen, even if you're married to a permanent resident and you are a victim of domestic violence, you can get U visa, which is not a green card, but it gives you status to remain in the US legally for 4 years. And I did have a question, David, when it says you're eligible to file for adjustment of status after holding U visa status for a period of 3 years, is it automatic, or do you have to find a employer who's going to sponsor you for green card? Do you need a separate grounds to get? Okay, so by the virtue of having had U visa for 3 years, you can self-petition?
Yes, absolutely.
Awesome. This is yours too.
Okay, then conditional permanent residence. So when somebody marries a U.S. citizen or a permanent resident and they're married for less than 2 years, at the time of the case being approved by law, the Immigration Service can only grant that person a card valid for 2 years. So, for example, if a person was married on July 1st, they had their green card interview today, they're approved today, they'll be granted conditional permanent residence today, December 19th, and that conditional green card status would be good until December 18th, 2024. They then need to file to remove the condition. That process currently is taking 2 years roughly with immigration. So probably by 2026, they'll have their conditional status removed. There is a basis for somebody to file to remove the condition, even if they're not living with their U.S. citizen or permanent resident sponsor. You know, if they're divorced and they can show that their marriage had been entered into in good faith. If they've been battered, they could also file to remove the condition. If they're separated, they can still file to remove the condition on their own. If they're like a victim of abuse, they can file and demonstrate that they're a victim of domestic violence. And then finally, if their sponsor is passed away, they can still file to remove the condition on their own without having the sponsor participate in that process.
Go ahead.
No, I know that the next slide, you had some questions about threats of deportation and domestic violence restraining orders. I don't know. I think you covered those.
Yeah, so when you have a client coming to you and saying, I have a green card, but it's conditional, and my spouse is threatening that he's not going to petition me to remove the condition, then I would be subjected to deportation, or that he would call the USCIS and say the marriage was not bona fide and have me deported. So timeline I meant to put there, so you are cognizant of what you're dealing with. As David just said, if you have a divorced person who has a conditional residency, just make sure that within the expiration of the conditional residency, you have the judgment on the divorce. Or if you have an abused spouse, then you don't have to worry about the timeline. But if you have somebody who is sort of, I'm not happy, I'm thinking about getting a divorce, and they have 1 year into the conditional residency, then you really have to think about, is this going to have a judgment entered before the 2 years so she can self-petition, or he can self-petition? Or do I tell her to wait it out until the condition is removed? How bad is the marriage? Can it be saved a little bit? So you have to think about the timeline. And of course, the threats of deportation, that's basis for domestic violence restraining order. So you don't have to be, you can assure the victim's spouse that she or he does not have to worry about that. And crime of moral turpitude. So there was a recent person asking me about, so my perpetrator husband is saying, if I don't dismiss my DV case, then he's going to file same thing against me. And he's saying he's a US citizen. So even if he gets a restraining order, it's a slap on his hand. But if I get a restraining order against me, that's a crime of moral turpitude. So that's subjecting me to potential deportation. Is there any teeth to that argument? David?
Sorry. Can you hear me?
Yes.
Okay, my headset, my Zoom is going back and forth between recognizing my earbuds and not. So my apologies on that. On the non-immigrant visa categories, briefly, other than the H or L visas, which allow for dual intent, if somebody had come to the US and fallen in love with a US citizen and they want to remain here rather than going through the process of applying for or having the US citizen sponsor them for a K-1 visa, they potentially could get married here and then apply directly to the immigration service for their green card interview. Now, there are some caveats to that. So, for example, there's a policy in place. It's a State Department policy. It's known as the 90-day rule, that in the event that somebody comes to the US in a certain type of visa, let's say as a visitor, and then within the first 90 days of their entry, they perform or they do some act that's not consistent with being here as a visitor, that fact could be used against them to make a determination that they committed a misrepresentation or a fraud in either applying for their visa or when they were inspected by the immigration officer at the port of entry, whether or not it's at the airport when they're arriving, or if they're driving in from Canada or Mexico, it would be at the land port of entry. So typically the scenario that we see is that you have like a US citizen who's in love with a foreign national has a visitor visa, they can come here to go to Disneyland, go to the beach, whatever, and they want to get married. And we kind of put the brakes on that because if they get married immediately after arriving here, that could be held against them by the immigration service, and immigration can make a finding that they committed misrepresentation. So again, we usually provide advice that if they're intended on getting married and then applying while they're here to stay here and apply for the green card here, that they should consider holding off on the wedding date until that's no longer an issue. Now, if a person is planning on coming here, getting married, and then is, perfectly fine with going back home and going through the process and waiting for the process to be completed back home, there's no problem with that. That is typically what happens in destination weddings anyway. People do consider the United States a destination for a wedding. And if there's a future immigration benefit that can arise from that, as long as a person is going to proceed with that process overseas, I don't see a problem for that. It's specifically for people, though, when they plan on coming here, getting married, and then staying here, that we usually provide the advice that, maybe they need to wait on the wedding plans until they've been here for at least 90 days.
I wanted to go back. I think David didn't hear my question. When there's a spouse threatening that issuance of domestic violence restraining order is a crime of moral turpitude, and if the person does not dismiss the case, then he will retaliate and file, and that would have her deported. Is there any truth to that allegation?
Well, they could always file and they could try to do something, but immigration is not necessarily going to act on person's requests or claims. Immigration does do their own investigations, and their main focus is not on these types of complaint-driven matters. They're busy enough with dealing with people that have existing criminal convictions, and their number one focus is on assessing whether or not a person with a criminal conviction is deportable. And then after that, it's most likely going to be employer sanctions investigations. So whenever anybody claims that they're going to file a complaint against the person with immigration, it's a really low priority for immigration, and they're not going to act on it, if at all. You know, the likelihood is it's not even going to even see the day of light. And that's also not going to be an act that would necessarily render a person inadmissible or subject to deportation.
Okay, but violation of a protective order is grounds for deportation, correct?
Yes, that is. However, you know, in talking to a client, again, how is that going to be a priority to the immigration service when they're, you know, they're limited in staff and there's not a focus, it's not a priority to them.
Got it.
The person really has to know like connections in order to get the immigration service to act on that, in my opinion.
Okay. Non-immigrant visa matters continue.
So it's something where I wanted to point out that on my side, you know, people that are not necessarily married, but they're in domestic partnerships are entitled to have their partner and potentially the children of that partner be entitled to be with them in the United States if they're on long-term visas. And so, for example, you might have somebody that's entitled to this working visa, the H-1B or the L-1 visa. If they're not married, their partner could apply for a visitor visa that would allow him or her to remain in the United States. It does not allow the person to work. They may only be admitted for a period of 6 months, whereas the person on the H-1 or the L-1 might be admitted for 3 years. So additional legwork would be required to ensure the person maintains their status. But there are options available to people that are in domestic partnerships that entitle them to be here in the U.S. Being in a domestic partnership will not allow the domestic partner to qualify for a green card, however. The immigration law will only recognize if a person's civilly married, either in the United States or in their home country. If a person may be in a situation where they're not eligible for a visa, but they're in a, you know, they need to be in the United States to be cared for by their parents or siblings, whatever the relationship may be. They may also be eligible to apply to immigration for what's known as humanitarian or public interest parole. So, for example, I had a case for a client where the mother and father and siblings got green cards through asylum, but they had a adult child that wasn't entitled to get the asylum green card. She was in Egypt and she needed the care and attention of her parents because she had a handicap that prevented her from taking care of herself or being, and also the Egyptian government did not protect her or the class of people that she was in. So we were able to get her paroled into the United States while the family were working on qualifying her for a green card. Somewhat the last kind of gasp for benefits, where if there's almost nothing else works for whatever reason, a person could potentially contact a senator's office or a congressional representative to try to get a private bill introduced in Congress to qualify for a green card. Those are incredibly challenging. I personally have never worked on one. I've worked at a law firm, my prior firm. We had a couple of cases that we're trying to work through and navigate through Congress, but they're incredibly challenging, and it's not an easy matter to get a private bill approved.
So when we come over to the family side, we're almost done. I apologize, we ran over. In REM jurisdiction in marital dissolution case, we need the court to have jurisdiction over the marital ray to terminate marital status. You normally think, oh, residency requirement, if you are in California for 6 months, you know, you're done. but not so. So read this case in my marriage of Obrecht. It's a 2016 case, and it goes into explaining what you need to prove that you have established the residency requirement in California for the court to terminate your divorce. And in divorce cases, in rem jurisdiction is governed by Family Code 2320, and it talks about the residency requirement. And what is residency? It's domicile for purposes of Family Code 2320. So what is domicile? Domicile requires both physical presence and an intent to remain in state indefinitely. This is what this case tells us, which is interesting. How can a non-immigrant have formed intent to remain in California indefinitely when they don't have an immigrant status, right? So when looking at the domiciliary intent, it can be determined in part from one's acts. So I put the 1984 case up there, and we also have that case in Elkins v. Moreno. An alien's non-permanent immigration status is a factor bearing on domiciliary intent. So it wouldn't automatically disqualify somebody from having formed residency in California, but it is a factor being considered. And in marriage of Dick, alien status can operate as an evidentiary fact against person's alleged intention to remain in the state permanently. And finally, Park versus Barr, this is a federal court case. Congress has not permitted B2 non-immigrants to lawfully form a subjective intent to remain in the US. Such an intent would inescapably conflict with Congress's definition of the non-immigrant classification. So in this case, somebody came in on B2, which is a visitor's visa, overstayed. So she became undocumented, married, and later on, the US citizen said she has no standing, or the California or the court can't exercise jurisdiction over our marital ray because she couldn't have formed the intent to remain in the state indefinitely. So I had a recent case just like this, where the spouse who wanted to divorce here was on O3 visa. It's a dependent visa of an O1, which is a work visa. This is a non-immigrant visa, and my client wanted to divorce in a foreign country, but the opposing party, wanted to divorce in California. So she said, I had formed my intent to remain in California indefinitely when we moved. But my argument was my client, who is the main visa holder, never had formed that intention. So the dependent of that visa, the holder of the dependent couldn't have formed an intent to remain in California indefinitely. Therefore, my motion to quash worked. So you can make arguments against the residency.
So Jinna, I have a question on that. So if the O3 dependent had filed a request to immigration to change status, let's say to student status, like F1 visa status, would that person's filing to change to F1 status be sufficient for a court to accept jurisdiction?
It could have confused the court more. It could have made the judge think a little longer. But because the residency requirement is at the onset of the case, when you filed your petition for divorce, have you had the 6 months established? So after the fact, applying for something different, I don't think would change the jurisdiction issue.
So what if the person then withdraws the court case and refiles after filing for the F1?
She can do that after she has established her non-immigrant status that allows her to remain here sort of longer, and it's independent of the spouse she's divorcing. She can do that. So I have mentioned if she really intended to remain here, she knew divorce was coming. It's been many months. She would have changed her status, but she didn't. Because she was using that to argue, I can't work. I need spousal support, but I can't go back to my home country because I had formed my intention to remain here indefinitely when I entered. So you can't eat a cake and you can't have a cake and eat it too. So David?
Yeah, so naturalization, this is a process where a person who's a permanent resident / green card holder wants to apply to become a US citizen. The normal policy or law requires that the permanent resident has to be a permanent resident for 5 years. However, there's a couple of exemptions to that. Somebody, as an example, somebody that's married to a US citizen and can demonstrate that they've been married to that person for 3 years while they've had their green card is eligible to apply to naturalize at that 3-year mark. So for example, if a person's a permanent resident for 4 years, gets married to a US citizen, they cannot just then immediately apply for naturalization. They would have to wait 3 years from the date of their marriage before they could apply under the 3-year rule. But on the other hand, for most of our clients, the person will have gotten their green card status through their marriage. And then at the 3-year mark, after they've had their green card status, they would be eligible to apply for their naturalization under this section 319.1 of the regulations. However, if they have a conditional or they have a case pending to remove the condition to their green card, which is often the situation, immigration will not act on the naturalization application until such time as they've made a determination as to whether or not they're going to remove the condition. Now, filing for the naturalization may actually trigger action on the pending case to remove the condition, but realistically, most often, it's a matter of pushing immigration by making inquiries on the case to remove conditions and possibly filing a mandamus case before the service will act on the naturalization application. The other possible rule that allows for somebody to apply for citizenship through naturalization faster than otherwise is if they can show that their spouse that's a US citizen has been assigned to work overseas, then as long as they're going to be overseas for more than 1 year, immigration does have the authority to naturalize the foreign national spouse, even if they've only had their green card for a day or two. And I've only had like a handful of cases where we've been able to present that as an argument, but it has been really efficient and immigration's processed those cases really quickly. The other thing that is important to know of is that if a person files under the 3-year rule, and they're married and they're living together with their spouse, that's a US citizen, but at some point during that processing time, they separate, immigration does not have the authority to grant the person their naturalization under the 3-year rule. They can only deny that application.
So I wanted to quickly comment on David's question about can the person refile after establishing residency. I also had another motion to quash, successful one, where the US citizen spouse, after having lived in Korea for 2 decades and having 2 kids in Korea, having assets in Korea, flies over to California and waits out 6 months and files for divorce here because he wanted a quick divorce. He didn't want to pay child support. He didn't want to do anything. He just wanted to divorce and marry the mistress. So the wife in Korea didn't want to get a divorce. And in Korea, it's fault-based, either fault-based litigation or both parties need to agree to divorce. So in Korea, he would have had a very difficult time getting a divorce because the party at fault has no right to divorce. So he would have to wait until she does something wrong to even have the right to divorce her. So we filed a motion to quash saying, on the day he says he arrived in California, he was texting his child saying, I'm at work in Korea. So we're saying he says he was here, but right here, the text says to the kid, he was working in Korea. So even if he arrived a couple days later, that would have made a difference whether he met the 6 months requirement or not. So I successfully quashed that proceeding. And like David said, he could have waited out a few more days and refile, but he didn't. I think they have a divorce case happening in Korea.
There's a question. What happens if the green card holder passes the 5-year mark? However, within the past 5 years, they had trips outside of the US, some of which were more than 6 months or even slightly more than a year. Does their 5-year mark start from scratch in that case?
So for the trips that are outside for more than 1 year, yes, the 5-year mark will restart upon their return to the US. It's actually not a 5-year mark. They have to be back in the US for 4 years and 1 day. And then at that point, they can then file. Now, there is an exemption to that because there is a form. It's a form N-470. That's an application to preserve residence despite a person's travel. If they could file that form ahead of any extended travel, and if immigration approves that application, the fact that they may be out of the country for more than 1 year won't matter. They'll still be eligible to be approved, at the file at the 5-year mark. The one caveat with the filing of the N-470, from my understanding of processing those applications, person needs to be physically present in the United States for the first year that they get their green card. If they make a single trip out of the US within that first year, the N-470 will be denied. Now, having said all that, for trips outside of the US that are less than 1 year in scope, but more than 6 months, immigration is going to look at the reason why the person's been out of the country. And if the person has a very strong reason for having had to be out of the country for an extended period of time, immigration does have the discretion to approve them as long as they otherwise meet the normal residence requirements. And just so most of the people here practice family law, for the 5-year green card or the 5-year naturalization, I should say, there's not only this requirement that you have to be able to show that you've been out of the US or you've had limited time out of the US, but you have to show that you've been physically present in the United States for at least 50% or 50.1% of the past 5 years since you got your green card to when you file. So that calculation basically is 913 days physically in the United States, because 5 years is a total of 1,825 days. If you're out of the US for 913 days, you are not eligible for naturalization, even if your trips are all less than 6 months. If you have like one trip out of the US within the 5 years, that trip happen to be like 300 days or something like that, immigration officers will look at the reasoning why you're out for so long. So for example, a lot of the applications I'm processing right now for clients is for individuals that qualified but for an extended trip that they made and they were stuck overseas during COVID. I have a lot of clients that had traveled prior to COVID. They went back to their home country for vacation. They were planning on only being out for a month. And then because of COVID shutdowns, they weren't able to get back on a plane for one reason or another. And they were out of the US for more than 6 months, less than 1 year. And consistently, I've had those cases approved by immigration. I've also had a person approved for immigration where she was back in Canada, where her mother had been diagnosed with cancer, and she was helping with her mother in her fight for cancer. Ultimately, her mother did pass away. Immigration recognized that was an extreme circumstance, and they granted her naturalization as well.
Okay, and then we still had that question from before. What happens if intending immigrant sponsor file everything, intending immigrant moves to the US, marries a sponsor, but within a few months of marriage, the sponsor files for divorce, withdraws sponsorship? mean, I guess that depends on if the green card was ever, if they were, I mean, I guess it's pending, right? And then they get a divorce while it's pending. What happens?
In that situation, I would look to see whether or not there's any claim to file a VAWA case, file a U case, if there's some sort of domestic violence charge that the person might thereafter qualify for a U visa, or look to see if there is a form of another non-immigrant visa that we could apply to immigration and ask immigration possibly to grant it on a non-pro-tunc basis. Otherwise, and particularly if it's somebody that came in under a K visa, if they do not get married and the person is not going to be eligible to file for adjustment of status, that person will have to leave the United States. And then in the future, they could look to see if there's any other visas that might be available for them.
But in the case, let's say they got, okay, you get the conditional and then you get a divorce. And I think a lot of people think that, you know, once you've gotten the conditional and you're in that period, that 2-year period, and then in the 2-year period, you get a divorce, a lot of people think, oh, well, then you're immediately done. And that's not true, right? Like, as long as you can
Right.
show bona fide marriage, you could still overcome the removal of conditions step by saying that, okay, we got a divorce, but this is the steps we took. We went to counseling. This is a real marriage. It wasn't, you know, we tried to save it, you know. So as long as, I think that's important also. So it's
So the one thing I would say with that type of scenario is if you file to remove the condition together with your spouse, and then while the case is pending, you do separate and you get divorced, I would, as a safeguard, file another petition to remove conditions just to have it on record and base that one upon the good faith, you know, you had entered into marriage in good faith, but unfortunately just got divorced.
to do a second one that doesn't have the spouse, the American spouse on there.
Right. Because immigration is going to, when the Immigration Service adjudicates the first one that was filed jointly, I think that their hands are kind of tied as far as approving that one. And they will otherwise accept and process the one that's filed without the spouse signing off on it.
Okay, well, I think that's it, right? I don't see any other questions.
Can I squeeze one more question? And I know we're over, but we appreciate you guys.
We're
Great
so over
depth of
that.
knowledge here. It's a short one. So does the 10-year sponsorship obligation persist if the sponsored spouse naturalizes? Or does the naturalization
support,
cut
right?
it short?
So if the sponsored spouse naturalizes, the affidavit of support disappears or the obligation disappears.
Okay. That would,
If you are unhappy and your spouse is a permanent resident, encourage her or him to get naturalized.
Yeah.
do that first.
That first.
Get your citizenship first.
And then also, it also disappears if the sponsored foreign national works for 40 fiscal quarters, which equals 10 years. So.
Oh, okay. Okay.
So keep in mind, Maggie, also that if a person gets their green card and then 3 years later they naturalize, it doesn't disappear at the 10-year mark. It disappears as soon as the person becomes a naturalized U.S. citizen.
Right. Good to know.
Thank you, everybody, for staying on for 30 more minutes, and you definitely will get CLE credit for 1.5 hours, not just one.
Right.
So Jinna and David, thank you so much for your time. I know it's a busy time of year, and pulling together such a comprehensive CLE for both immigration and family law practitioners is such a treat. And so thank you really so much for doing this for us.
Thanks for having us.
Yeah, absolutely. Thank you.
To those who are still on, we are in the process of firming up, but have confirmation that we'll be doing an ethics for immigration lawyers CLE on January 9th, just before the January cutoff. So if you're missing your ethics CLE, watch for that. That will be on January 9th. And then we have our immigration section meeting will be, is it the 11th, Joanne?
I think.
Do you want to advertise when the family section's next meeting will be?
I think it's this week. And we also have an implicit bias panel coming up on the 23rd of January. So yeah, keep an eye out for the email blast.
So much good stuff coming up. Thank you very much. I would like to point out that today's panel is 50% Canadian. There we go. Thanks everybody for joining us. Thank you, David and Jinna. And I hope everyone has restful holidays, however you are celebrating.
Thank you. Happy
Thank you.
holidays.
Happy